Somebody sent me this video thinking that it refuted my claims in trespassing in Colorado video, and it doesn't. We'll listen to it. We'll see what Max Millionaire 1 has to say. We'll see his insightful legal analysis, and we'll debunk it.
Stating that no verbal notice is required before arresting somebody, and no signs are required before arresting somebody to let them know that you're not supposed to go on public property. And I understand that those particular words are not in the statute under third-degree criminal trespass. It just says unlawful entry onto the property of another. But when you go look at section 18-4-201 subsection 3 of the CRS, it defines what unlawful entry is. And the definition says that you're privileged to go onto the property unless you've been notified verbally that you cannot, or there's a sign posted at the entrance stating private property or no entry or something to that effect, or at the very least one sign every 440 yards. And it refers to private property, private land, three times it references private. And I don't see how, if that's the definition of unlawful entry, first of all, I don't see how that applies to public property. And second of all, as the definition of unlawful entry, that is part of your code, part of your trespassing code, which, Deputy Tanner simply said that.
All right, so that's enough. So looking at the code, we've got 18-4-504. A person commits a crime of third-degree criminal trespass if he unlawfully enters or remains in or upon the premises of another. Another's pretty easy. Weld County is an entity. Weld County owns that property. Premises, we know is real property. Real property is land. So premises of another, the land of Weld County. That's easy. So you're looking at unlawfully enters or remains in or upon. So he skipped a lot of this stuff. We went over it. Basically, you have to show that you're licensed, invited, or otherwise privileged. That's the only way that you get out of entering unlawfully or remaining unlawfully. He focused on this section right here. He says that you had to have a sign every 440 yards. You have to state it verbally, or you have to put a sign up at the entrance. So this is the part he was looking at, and let's read it to see where he screwed the pooch. A person who enters or remains upon unimproved and apparently unused land that is neither fenced nor otherwise enclosed in a manner designed to exclude intruders does so with license and privilege. So you'd have license and privilege if you entered upon unimproved and apparently unused land. Well, where does this go wrong? Is it unimproved? Absolutely, it's unimproved. So we've got a win there, but the apparently unused is still not going to work. It is used for storing wrecked police cruisers. That is the whole reason Cybertron Photography entered it, because he noticed that that land was being used for storing wrecked police cruisers. And this guy, Max Millionaire, also loves to say, oh, it's public land, it's public land, it's public land. That's not the test. There is nothing in the statute or in the definitions that say public land. What they do say is open to the public. Now, what does open to the public mean? There's no statutory definition for it. So you go to cases. This is People v. Bozeman. This is a Colorado Court of Appeals case. And given the above statutory language, the essential question here becomes whether the Admiral Freight Terminal was open to the public. So they're going to define open to the public, and they define open to the public means premises which by their physical nature, function, custom, usage, notice or lack thereof, or other circumstances at the time would cause a reasonable person to believe no permission to enter or remain is required. Now, you are thinking you're a reasonable person, and you're not, nor am I, so don't take that personally. The reasonable person is going to be the finder of fact, which in this case, since it is a misdemeanor with a maximum jail time of up to 6 months, you don't get a jury. You're not necessarily going to get a jury, so it's probably going to be the judge looking at it, but if it is a jury, then great. So it's going to be either the judge or the jury that's the reasonable person. In this case, since it's a Court of Appeals decision, there are 3 judges, and they say, applying that definition here, we conclude that a reasonable person would not be led to believe that he had permission to enter or remain within the Admiral premises, unless his presence was incident to a lawful business purpose in which event no permission to enter or remain would be required. Now you're thinking, Cybertron Photography had a lawful business purpose, but he did not. The record shows that the Admiral Terminal building was not a public building in the sense that a department store or airline terminal is a public building. The general public is not invited onto the premises for non-specific business purposes. Just like this field, the public is not invited onto the field for non-specific business purposes. Although there are no signs or notices on any of the building entrances or exits notifying members of the public of any restriction or limitation on their access to the building, Admiral's premises are not designed or advertised for use as a public structure. Likewise, this field is not designed or advertised for use by the public. By the very nature of its layout, design, location, it's apparent that its function is solely to facilitate the unloading, handling, and storage of freight. Similarly, by the very nature of its layout, design, and location, it's apparent that that field is solely to facilitate the storage of the wrecked police cruisers. The only persons with reason or authorization to enter the warehouse are employees of Admiral or persons there for a specific business purpose, and that specific business purpose has to relate to Admiral. In this case, the only persons with specific reason or authorization to enter that field are employees of the Weld County Motor Services Pool or persons there for a specific business purpose with the motor pool. Going in there to film wrecked police cruisers, while it may be fun, is not a specific business purpose. Here, there was no contention that the defendant was an employee or had any business purpose in the terminal, and evidence establishes this to be the fact. Hence, the element of entering or remaining on the subject premises was adequately demonstrated by the prosecutor's evidence. You have to be there for the business's purpose. If it's not open to the public, you have to be there. Just like in Adderley v. Florida, the state can control the use of its properties for their specific purposes. So a library is there for you to check out books and read it. A courthouse is there to conduct court business. A Weld County motor pool is there to deal with Weld County vehicles. It's not for you to come in and film. You may disagree with that. You may wish it to be otherwise, but that's the nature of the issue. So now we know what public place or what open to the public means. So we know that this portion doesn't apply. So it's none of the exceptions, none of the things that give you license, invitation, or privilege to be on that property apply. So he would be remaining there unlawfully or entering unlawfully. This is the Judicial Department, Colorado Judicial Department's criminal jury instructions. It is for 2016, but they haven't released a new one yet. I am at their official website. Obviously, it will be linked below. It's a 3,317-page document, so enjoy it. But they give the elements of third-degree criminal trespass. You'll notice the elements of third-degree criminal trespass are that the defendant, so they have to prove that it was Cybertron photography. In the state of Colorado, at or about the date and place charged, they have to prove it was in the state of Chicago, it was at the Weld County motor pool. They have to prove the date and time that, or the date that he was there. So we know all that. That's not bad. Has to be unlawfully, which means that it's without privilege, license, or invitation, entered or remained. Entered, he stepped onto the property. We know he entered. In or on the premises of another. We've defined premises as real property. We've defined another as Weld County. Bada boom, bada bing. Unless he finds some affirmative defense like justification or insanity or something else, he hit all of the elements. And he would have to raise any affirmative defenses. And until he does, I can't tell you whether his affirmative defenses are good. So after considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of third-degree criminal trespass. Now, I'm not saying this to gloat. Cybertron photography seems like a reasonably decent fella. I mean, I don't have any feelings for him one way or another. I know that he's apparently going through some hard financial times. I don't personally want to see him fined or imprisoned under the statute. But the facts are the facts and the law is the law, and all I can do is apply the facts to the law and tell you the most probable outcome. And in this case, the most probable outcome is that he gets found guilty of third-degree criminal trespass. Now, I hope the prosecutor drops the case. If the prosecutor doesn't drop the case, I hope the judge gives him the most minimal sentence possible, or minimum fine, $25 or whatever. That'd be great. But I mean, he did it. He ticks all the boxes. So it's unfortunate, but there it is. And Maxim Millionaire One has no business giving legal advice, or legal analysis, I should say. And another thing that's really stupid is calling up the police to argue with them that their enforcement of a statute is somehow wrong is pretty stupid. A judge determines what a statute is, how it is to be interpreted, not the police. So if you say to the police you're interpreting the statute wrong in your enforcement of it, it's meaningless. It's up to a judge. The judge determines it, even if you convince the police that their interpretation is wrong. A prosecutor, a judge, somebody's going to inform them that you're full of it, and you're just wasting time and money. Anyway, thanks to the person that sent me this. I sort of appreciated it. Was a waste of time, but hey, I like interaction, and if you have questions, feel free to ask. Have a great day.